questions. It's a lot easier to know, oh, well, I know this is what I am. I know that. When I've been called on to testify at various times, and I said, well, I ask what I always ask. And I named the 4 questions. Because they're going to bring the witness in. And the witness is not going to be in there when I get examined. And so the witness can then say, well, these are the 4 questions that were asked. Because they were asked. They know that. But a good attorney will try to trip up the witness and a lawyer. They'll try to get them to describe a different scenario. So if you ask those same questions every single time, you never have to worry about it. When you're preparing the witness, you can tell the witness, do you remember when we signed the will? That's what it said.
I learned a valuable lesson early on. One of the first judicial appointments I ever got, it was a guardian ad litem for a whereabouts unknown in a probate proceeding, and I called for an examination of witnesses, and the testimony was, I'm an employee at M&T Bank. Mrs. Smith came in and asked me to notarize something. And what did you do? I notarized it. Did you do anything else? No. Did Mrs. Smith say anything else? No. I made a motion for summary judgment. The will was denied probate.
Yeah.
Because she said she, quote, notarized it.
Yeah.
Didn't pronounce it to be her last will and testament. Didn't say, will you act as my witness? So that whole due execution routine is something that you really need to concentrate on.
You do, and the witnesses have to know that.
And then this was the case where they found a prior will, and so then they probated that one, which had completely different beneficiaries.
Yeah.
So the results can be disastrous if you don't
they really
watch
can.
the proper execution phases.
Yep. And then you have the testator signs, and then the witnesses sign. And then we also do a proof of will. That we have both witnesses sign. I don't think I may not have a copy of that in here. If I don't, Bob, I don't think I do. I can email that down to you.
Okay.
But when we file the will, we file the proof of will with it.
The contemporaneous proof of will?
Contemporaneous proof of will. That way, when you probate the will, you don't have to look all over high heavens trying to find the witnesses to the will to file it. So it makes for a much more expeditious probate of the will. Yes.
Would this proof of will contain, what was asked of the testator and things like that in an affidavit form? Is that?
The boilerplate language.
Yeah, it's all boilerplate language.
Okay.
It just says that we were asked by the testator to be witnesses, that he affirmed that it was his last will and testament in our presence, and that we're signing that.
But then you need 3 people, right, instead of 2?
No, 2.
Doesn't somebody have to act as the notary?
No. Well, you have to have a separate note. You have to have a notary for the 2 witnesses. But they can sign that. I mean, I have people in my office that are notaries. They can do that.
But when I started practicing, it always would be that the attorney would be one witness, and then you'd call in the secretary or the paralegal, and she would be the other witness. Now it seems like the better procedure is the attorney acts as supervisor. There are 2 separate witnesses, and then there's somebody who notarizes the signature.
Yeah.
So it seems like it's a bigger room full of people now, but it saves a lot of time on the back end.
It does. Although I still witness. I still serve as a witness for my wills. But I do the contemporaneous proof of will. So, I mean, I'm hoping most of the people I'm doing these wills for are going to probate them either after I have retired or I'm no longer here. So I'm just trying to make it easier for the people that come after me. But the rest of the materials, I'm going way over time here, but what we have are these are a number of optional clauses that you can insert in the will. One thing is a minor's clause, and we put this in. It's not as significant as it was in the days when Judge Matina was a surrogate, because Judge Howe she recognizes that people are adults at age 18, But what we do is we put in a clause, we try to set this up so that we don't have to open up a guardian account in the surrogate's court for the minor. That's very burdensome on the family who's trying to administer that estate. Every time you want money, you have to get approval, you got to petition, you can't. So this allows for some flexibility if you have the minors clause in. And then here's the guardian's clause. I nominate and appoint the surviving parent or court-appointed guardian. This is to be the trustee. If you're going to name the trust, if a child predeceases and they leave children and it's going to go to the grandchildren in trust, you want to add this sentence in: who are you going to appoint as the trustee of that trust? And we generally appoint the surviving parent or a guardian. Sometimes they won't. I've had people come down and say, I don't trust my daughter's husband. I don't trust him. I think he'll get that money and he'll take it. I don't want him to be the trustee. So you name someone else. But generally you want the surviving parent. That makes the most sense. Yes.
If someone wants to do something creative in terms of, like, I had someone ask me about, they had 2 children, but they wanted to leave only one child a part of their assets, and then the other child they didn't want to leave anything to, but wanted to leave it to that child's children, their grandchildren. Do you suggest that they put an explanation of why within the will, or should they just maybe put an accompanying letter?
Well, sometimes you can put in a phrase that, I intentionally, let's see if I have that here.
And aren't the notes in the attorney's file discoverable in a probate proceeding? Like if you, as the attorney, you wrote down notes and my client specifically didn't want to leave information, isn't that something that is not subject to attorney-client privilege after the person dies and has to disclose?
They could discover it.
Yeah.
But we put in a clause that says I intentionally am not leaving, I make no bequest to my child by name for reasons known to me, or I've made previous arrangements. But you put a sentence like that in there. You don't have to. You're not obligated to leave anything to anybody.
Right.
A lot of people come in and say, I want to leave $1, because if I leave them $1, then they can't contest it. I said, no.
Is that how it works?
No, that's not true. They can't. So then we can just go through it, but this is like balance of outstanding debts from children. This was what we were talking about before, Greg, that it's sort of an evening out provision.
Yes.
And so you can make provisions for that I either gave them money or I lent them money and now I'm forgiving it, or but you can work with that.
Because I like to use that in conjunction with the if you contest the will, you get nothing.
I do have I have the inter orum clause in here as well. And this is the executive powers clause. That was in the sample will that we looked at. A guardian clause for children, that just, in the event both parents die and they're minor children, who would you like to have as a guardian? My youngest daughter is 16. My wife and I did not name anyone in either of our families to be the guardians. I'm just hoping that we both make it till she's 18. There'll be no prayers for either of us if the family finds out what we did. Minor's clause, when a will contains a trust. Here's the no contest clause. Did you have a
Can I ask you a question about the guardian clause?
Yeah.
Is it your experience that unless somebody was to come in and contest the guardian clause, saying they want to be the guardian,
Right.
that the surrogate doesn't really look into that much? Do they just go with this, or what kind of investigation do they do?
You still,
You mean like if the guardian's a convicted felon, is the
Well,
judge gonna discover
no,
that kind of
Well,
thing?
not necessarily that, but
Well,
I'm just wondering how much of an investigation
Well,
do they do?
here's what would, there would, because they're minor children, there would be a guardian ad litem appointed, and I think the judge would rely on the guardian to, the guardian's report, the guardian will investigate the parents. If he or she saw some real problem and pointed that out, then I think they would further investigate.
But it's not like a regular
It's
guardianship
not like an
proceeding
Article 17A,
or where they do a home study and things like that.
no. But, although they could, the guardian ad litem could do that.
If something,
Yeah.
there's a red flag, basically.
You know, or if, if a sister or somebody called and said, I gotta tell you about my brother. You know, he's,
Someone drops the dime on him.
yeah,
Right.
then the guardian ad litem, I think, would conduct a deeper, more thorough investigation.
Okay.
But the guardian is there to represent the children's interests. The minor's clause when a will contains a trust, we actually had that one in the sample will. Here's the no contest clause, that's the interorum. This is interesting because it says if any beneficiary in any manner directly or indirectly contests this will, so if you disinherit a child,
Oh, then they're not a benefit.
and you put the interorum clause in there, then they can still attack the will and not get knocked out.
So there you should leave $1.
That's when you want, if that's what you want, you leave them at $1, that's
Yeah.
right. Yep. And then this is the language to nominate the trustees. The right of election that we talked about earlier. This is really important as people get older. When they've reached the point where the spouse doesn't need to get everything and they want to redo their wills, even if they're not looking at an imminent nursing home, I suggest putting in this language. Just because you don't want someone 90 years old to get assets that they don't really need. It's something you don't want to do. It can complicate it and can really make it difficult if they do require some type of long-term care, because that's when you get to know the kids. We want to make sure that we preserve the assets that we know mom and dad wanted to preserve. This is an interesting clause. It's called the round robin distribution. Sometimes you have families that just can't figure out what to do with the personal property. This is one way of doing it. You can put it right in the will. It just says, one person gets an item and you go down and then you can reverse the order, or something that I've used. I've actually been pretty successful with this in wills that don't have this language. I give everybody a stickum pad, different color. However many kids there are, they get a stickum pad with a different color. I tell them, go through the house and put a stickum on everything that you want. Everything. I suggest, whatever it is you want, put it on there. And then when they do that, then I go in the house. I get whatever one has 2 or more stickers on it, I get that item and I put the names on it. And then sort of piecing one against the other, you can really get them to agree. They really can come down. It's always worked out. Before that, I want this bureau, and she promised me this china, and blah, blah, blah. But they're really not fighting over the same things. The battles are in their minds. They're fighting with mom or dad for dying, and they can't stand it. Most of them are just heartbroken. So this way we can sort it out, and then I can sit down with them and I can say, all right, well, you both want a rug and you both want a couch. One of you take the couch, one of you take the rug. Let's flip a coin. And I've had a lot of success with that. That's been very successful.
I used it in a situation where there was a lot of like sterling silver and jewelry and you just put it all in the middle of the room and everybody took
Yeah.
turns picking around in a circle
That's-
until everything was gone.
That's a round robin.
Yeah, and
Yeah.
I didn't know if I was making that up or if there was some authority from it somewhere, but that's the way I did it.
Good way to do it. Here's the authority for it is, did it get done? That's the key.
And everybody's happy, or somewhat, semi.
And then I have a simultaneous death clause. Some people are concerned about that. That's the standard simultaneous death clause. It says if you both die at the same time, it's presumed that the testator predeceased. We have the supplemental needs language. If you're going to, if you have a disabled child, you want to know that. It's really important when you're drafting a will. And then again, another the trust for children form. Then the last document in the package. I went through those pretty quickly. If you have any questions, I'd be happy to answer them. But they're pretty standard forms. And then the last document in the package shows you the different types of will substitutes. And those are things that you can do. Really depends on the client and their assets. But these are ways to everything on the right hand side of that page are ways that you can title assets so that there's no that they're not part of the probate estate. And the will only covers assets that are in the sole name of the testator. So, if you have any questions, I'm happy to ask any questions that you have.
I
Yes.
just had a quick question about how you mentioned that joint account situation.
Yes.
Do the courts even look into an intent if it's a joint account? I mean, isn't that automatically?
Banking law, section
No.
6,
Yeah,
what is it?
you
600 something of the banking law is a presumption.
there's a presumption, but you can challenge it.
Yeah.
And so it all becomes circumstantial. When did they open the account, and how long was it that way? How long did they have access? What did what was said?
Mm-hmm.
You kept running into problems with the dead man statute because you can't use the testator's
Yeah.
words. So it's difficult but not impossible. A lot of times these accounts are opened up just shortly before death. You can get maybe the joint owner will have told a brother or sister they know that this is why they're doing it, and then you can bring that in. But there are a line of cases where you can challenge that has been successfully challenged. And a lot of times what happens is that you just settle it. People begin to see that the cost of these legal fees is going to exceed the value of the account, so it's time to stop. But there are a series of cases that have upheld a challenge to the joint ownership. Anyone else have any questions? Well, thank you very much.